That's not too many.
All right, what case are we calling first, gentlemen?
All right, so we would be calling Mr. Kawar. Howard.
Keon
Yes, Mr. Keon Coward.
Howard. All right, so we're on the record in docket 2601313. That is People of the State of Michigan versus Keon Coward. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court. Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people of the state of Michigan.
And Mr. Harris.
Yes, Your Honor. Assistant Public Defender James Harris here on behalf of Mr. Coward, who is standing to my right. Mr. Coward, if you could please state your first and last name for the record.
All right, this is the time set for a jury trial in the matter. Mr. Smith, how are we proceeding? Would you like to defer to Mr. Harris?
At this time, Your Honor, the people are understanding that the defendant is going to enter a guilty plea as charged under 769.4A, and this matter is going to be set for pre-sentence investigation.
That is my understanding as well, Your Honor. The prosecution has extended an offer where if Mr. Coward was willing to plead guilty, they would be willing to agree to the 769.4A status, as well as agree to I believe, a likely term of probation, as probation would be necessary for that status. And I've spoken with Mr. Coward regarding this case and regarding our options. He has indicated that he wants to accept that offer at this time. So we would be requesting the court to refer this matter to probation for that pre-sentence investigation report.
All right, may I inquire of your client of his advice of rights?
Yes, Your Honor.
Mr. Coward, you understand you have the following rights, and I'm going to walk you through them, okay? You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by Attorney James Harris, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
Yes, sir.
You understand that you have the right to have the court order any witnesses appearing in your defense remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what was been stated on the record or threats that was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading guilty to the charge of domestic violence instead. Is it still your wish today to plead guilty to the charge of domestic violence?
Yes, sir.
All right. If you raise your right hand as best you can, do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
I'm going to bring your attention back to May 14th of 2026 at the offense location of 1136 Platt Street in the city of Lansing. Were you at the city of Lansing address 1136 Platt Street on May 14th, 2026?
Yes, sir.
All right. And who is Whitney Genty to you?
His mom.
So that's your kid's mom.
Yeah.
Okay. What did you do in relation to Whitney Genty that makes you guilty of domestic violence that was not done in self-defense?
She wasn't trying to leave my house, so I was trying to basically drag her by her feet, trying to get her out of the house.
All right. So you offensively touched her.
Yeah.
Okay.
I ain't literally put my hands on her.
And you, so say that again, sir.
I ain't physically put my hands on her, like open hands. I just try to drag her out of the house by her feet.
Say it again. I
Try to
don't.
get her out of the house by her feet.
Yes, I believe what Mr. Coward was trying to indicate was that he didn't physically assault or hit her, but he was grabbing onto her and dragging her by her feet, which I believe would be sufficient to consist as an offensive touch.
And she did not want to be touched at that time. Is that correct? Okay. So you weren't doing so in self-defense? You weren't defending
Oh, no.
yourself? All right. Anything towards the factual basis of Mr. Smith?
People are satisfied, Your Honor.
Mr. Harris?
Defense is satisfied, Your Honor.
I find the plea to the charge to be knowing, voluntarily, and accurately made, and will refer to probation. So the sentencing date, well, for probation is one floor down all the way to your right. And they'll do, essentially, they'll do a report for me. But what they're really going to be looking at is the 769-4A status, because that's abstracted differently. So I'll refer to probation, and it is set, and we'll set the sentencing for August 17th at 1:30. All right, so we've set the sentencing for August 17th at 1:30. I'm going to refer you to probation, and we'll see what options are available to us on August 17th at 1:30. All right, sir? Anything else for the record in 26-01313, Mr. Smith?
Yes, Your Honor. I had an opportunity to speak with the complaining witness in this case. And I reviewed the pretrial conditions. One of the pretrial conditions is that the defendant was not to have any contact with the 3 minor children. This case does not involve the 3 minor children, and the complaining witnesses asked us to have the court remove that section of the pretrial prohibitions. So I believe she should be online if you need to speak with her directly, but I'm asking the court to remove that section, keep the no contact order in place for the complaining witness, but allow the defendant to have contact with his 3 minor children.
You have the P53
Your
was
Honor,
set by Magistrate Milmore. Mr. Harris?
yes, I believe the complaining witness should be here on Zoom. I believe it would be a Miss Whitney Genty. And the defense would have no objection to that, to the no contact order regarding the children being lifted at this time. If the court is willing to lift that, I would request that the court would perhaps permit third-party contact for purposes of childcare to for custody or for helping to establish contact with children without having Mr. Coward contacting Ms. Jensen.
All right. Let's hear from Miss, is it Genty?
And then I believe
Whitney Genty?
I believe Mr. Smith was on Zoom to speak with a Mr. Ruiz if he's here.
All right, Mr. Smith, did you need to speak with someone?
Yes, Your Honor, I need to speak with Mr. Ruiz.
And Mr. and
I can see them on the road.
is he the Motorola or the Samsung?
It's not clear to me. I'll see if I can.
All right, on the Motorola Moto G, would you please identify yourself on that cell phone? On the Samsung cell phone, could you please identify yourself? Right. Ms. Genty, would you please identify, you can unmute? Whitney Genty?
Yes,
All right, and ma'am, you are Whitney Genty, is that correct?
yes,
It's my understanding that you are the prosecutors made a motion concerning the lifting of the no contact order involving the 3 minor children in this matter.
yes.
Did you have anything to say on that, ma'am?
No,
So did you want the no contact lifted?
yes, for the kids, yes.
And why was the no contact placed in the first place?
I have no clue. I thought it was supposed to just be for me, but turned out that they put it for the kids as well.
Mr. Harris,
Yes,
do
Your
you know
Honor.
why the magistrate placed the no contact with the three minor children? I see them, the only thing I can think of is that they're living at the residence.
That would be my guess. However, I'm not certain why a no contact order would have been placed regarding the children, given there weren't any allegations of child abuse or anything done involving the children.
I have that, so that would be, yeah, there's no allegations concerning child abuse other than the domestic violence occurred in front of the children. And then I have date of birth for the children are 2020, 2022, and 2025. Is that correct?
I believe so. Your Honor.
All right. Well, I'm going to lift the no contact order. In regards to the children, at the request of the prosecutor, but I'm going to keep it in terms of Miss Genty. Two, three minor children. No contact order is kept in place in regards to Miss Genty. All right, so the no contact order is lifted in regard to the minor children. You can see the minor children. It's still covered by whatever family court orders is out there. But you still have a no contact order in relation to Miss Genty. There was not a GPS placed on, so you're still under no contact order with Miss Genty, okay? All right, Miss Genty, thank you for your appearance today.
Thank you.
And so probation will either see you now or we'll make an appointment to see you, but we'll see what's available to us on August 17th at 1:30. All right, sir? All right, you should be all set. Thank you.
I just.
We're doing 769.
Yeah, we'll move on to
769 40 steps. Go and put it in all the other. Yeah. All right, what are we calling next, Mr. Smith?
Taekwon King, Your Honor.
Okay. And send us Mr. Ruiz. On the cell phone, sir, could you please unmute? You are in your, it looks like you're in a motor vehicle. I can't hear you. So you're gonna have to unmute.
I said, yes, I am currently, yes.
Okay, and you are Mr. Ruiz?
Yes.
All right. All right, I'm gonna put you in a breakout room with Mr. Smith. So, Mr. Smith, I'm going to place you in room 1, and I'll place Mr. Ruiz in room 1.
So she has appeared today. She's updated her phone number with us. We're just need a couple days to prepare for trial in this case. So we're asking that the matter be adjourned and that the jury trial be set.
I'm confused.
If I may, Your Honor.
Mr. Harris.
Or in the alternative, Your Honor, we'll dismiss and refile.
My understanding, Your Honor, is that I unfortunately wasn't here as I got sick that day. Mr. Smith is covering for me and is going to be a second chair of sorts on this trial. My understanding is the final pretrial was on June 15th, and I believe the complaining witness was here that day. And then it's been about 3 weeks since then. I understand if this was an issue, my thought was should have been regarding contact, it should have been brought up when the complaining witness is here for the final pretrial. The defense is here. We are ready to proceed. We were under the impression we were running a jury trial today. At this point in time, we would be objecting to any request for an adjournment. I have gone over the possibility of the charges being dismissed and reissued with Mr. King and what that would mean. He still indicates that he would be objecting, that he and myself and Mr. Smith would be objecting to the adjournment request at this time. I would request if the court would be willing to grant defendant's motion to dismiss at this time and to not grant the motion for an adjournment. And I understand that that is a dismissal without prejudice and that the prosecution could potentially refile.
Right, we had a final pretrial on this on June 15th. And we set it for jury trial today. And then we were supposed to have instructions on the jury trial a week before.
Yes.
And I received them from yourself, Mr. Harris. I received nothing from the prosecutor's office.
Yeah, that's correct, Your Honor. Again, we attempted to contact her. It's unfortunate we have the incorrect telephone number. But Your Honor, again, if you're not, the court is not prepared to enter an adjournment, again, we could dismiss and we will refile. It's not a matter of whether or not we're going to refile. We are going to refile. And if we have to dismiss, I'm going to do that as soon as I get back to you. So.
This was a case that came back from circuit court, is that?
There was a telephone interference with a felony that did come back, and the only charge that's left is the misdemeanor domestic violence. We just need time to prepare, since we have the complaining witnesses correct contact information.
Right, so was count one made, was dismissed in circuit court? What are the counts? I know the DV is a 93-day.
Yes.
What's the count one?
Count one was interference with electronic communication.
That's the 2-year. What did we end up with it? Because I bound this over.
Let me.
We have the prelim, we bound it over. The complaining victim testified, we bound it over. And then it was sent back. And then the defendant failed to appear on March 9th. We did a bench warrant arraignment on May 6th. We reset it for June 1st. We had a final pretrial on June 15th. And Ms. Miles was at the final pretrial. And the indication is, for the record, the people are unprepared to go forward today because you didn't have a number for Ms. Miles.
Yes, so it appears that the same thing happened over in the circuit court, is where we had incorrect contact information. So they were not able to make that, make out the felony count.
Your Honor, if I
So,
may. Your Honor, if I may.
You may, I'm trying to figure out the history of the case here, and I think I've got it.
Yeah, I would simply point out, if this was, I believe that matter was in circuit court in November of last year. If this was an issue up at circuit court and has been an issue, that would indicate to me that this issue has been known and that this issue has been ongoing for near on 9 to 10 months now. And if the prosecutor, and my understanding is that the fact that we're at a jury trial today means that the complaining witness was here at the final pretrial back on June 15th. If the prosecution is indicating that they haven't been able to get that phone number despite having contact with her at least once, if not multiple times over the past 8 or 9 months, to me, that seems a bit unfairly prejudicial to my client to then grant an adjournment over a phone number they have had 8 or 9 months to get now.
well, Your Honor, if I may, I would caution defense counsel, if we do dismiss this case, we could potentially refile with the felony count added, and we can go over, and this could go back to circuit court. So, I mean,
That hasn't worked in the past. We had a prelim on this case.
well, again, I think
We had a prelim, I had the witness testify, and we bound it over, and now we're back in district court. And I'm trying to figure out why.
I just have notes that at the final pretrial in the circuit court, that we didn't have good contact information from the complaining witness at that time. So they were unprepared to move forward with the felony.
So we
count.
just made it misdemeanors and sent it back to district court.
And so they just got rid of the felony and went, kicked it back down. You're correct, Your Honor. So,
Well, Mr. Smith, you are living up to your reputation. All right. I'm going to dismiss this case without prejudice. This case will be reissued. You know that. It's going to start from day one. I would think you were arraigned in April of last year. It's going to all start again. Okay. And I may or may not get the case, but I don't know what you're going to be arraigned on, but I'm going to dismiss without prejudice based on defendant's motion. I will sign the order of dismissal so Mr. Smith can keep in contact with Mr. Harris, and you will be rearranged, sir. Mr. Smith's indicated that he plans to reissue today. So sometime this week, I would think.
Your Honor, may I say one thing?
You probably should with your lawyer next to her.
Ms. Miles was at circuit court multiple times, and I also had a final pretrial with circuit court. When I went in and they changed the tampering with phone line and they dropped it, that was supposed to be my final pretrial with circuit court.
Well, you're starting the process all over again. Okay. So I'm going to dismiss without prejudice. So there's count 1 of interfering with electronic communications, the domestic violence, and the attempt interfering with electronic communications. I would think it's count 1 and count 2 now.
yeah,
Since that's all right. I'll sign the nollie pros So this is being dismissed without prejudice, which means, Mr. King, that this could be reissued and it will be reissued, okay? According to Mr. Smith, the prosecutor. Anything else for the record in 25-01167, Mr. Smith?
Nothing from the people, Your Honor.
Mr. Harris.
Nothing from the defense, Your Honor.
All right, Mr. King, I don't know what judge you'll be in front of when you're rearranged on this. But this case is all done. You're free to go today. All right, which case are we calling next, Mr. Smith?
Your Honor, we are prepared to go on Benavides.
All right, so we're on the record in 26-00087. That is people of the state of Michigan versus Jalista Benavides. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Mr. Harris. Mr. Rabat.
Student Attorney Alex Rabat requesting permission to practice pursuant to Michigan Court Rules, Chapter 8, Section 120, under Assistant Public Defender James Harris.
All right, it's granted today, and you only have to make that motion one time today. And so you're here for the Public Defender's Office, and sir, you are Jalista Benavides, is that correct? All right, is that pronounced correctly? All right, thank you. This is the time set for a final pretrial in the matter. Mr. Smith, how are we proceeding?
Thank you, Your Honor. At this time, the people move to dismiss this case. We've attempted to reach out to the complaining witness. That individual is not here today. We've made multiple attempts to reach that individual, been unsuccessful. So at this time, the people move to dismiss.
All right, the complaining victim was subpoenaed, is that correct?
Yes, Your Honor.
Mr. Rabat.
No objections to the dismissal, Your Honor. We would just request that a copy of the dismissal be provided to Mr. Benavides.
All right, so I will at the people's request will dismiss without prejudice based on the representations of the prosecutor's office that the complaining victim was subpoenaed, has failed to appear today. And any contact to get the complaining victim here has been unsuccessful. And I'll entertain a nollie pros to be signed by Mr. Smith that I'll also sign. I do not have a GPS. There's a no contact order. So I would keep the dismissal with you for about 4 hours. It takes about 4 hours to purge from the court system, okay? Yeah, so have Mr. Smith date that.
Thank you.
Thank you. All right, I will sign this. So you should, we'll provide a copy. You should keep a copy with you. There is no GPS. Anything else for the record in 26-00087, Mr. Smith?
Nothing from the people, Your Honor.
Mr. Harris.
Nothing from the
Or
defense.
Mr.
Your Honor.
Rob, I'm sorry.
Nothing further, Your Honor.
All right, keep a copy with you. We'll provide the copy for your records. That's all for the record in 26-00087. On the Motorola cell phone, could you please identify yourself? You're unmuted. On the Motorola cell phone, would you please identify yourself? All right, Mr. Smith, Mr. Tyler Smith, are you ready on Mr. Reese?
Yes, I am.
All right, let's go on that case. So that's 2 final pre-trials.
That's correct, Your Honor.
All right, Mr. Ruiz, you can unmute. All right, you're still on mute, Mr. Ruiz. There you go.
There I go.
All right, so we're on the record in docket 26-01390 and 26-01406. That is people of the state of Michigan versus Joseph Ruiz. Or Reese, appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, appear on behalf of the people.
Mr. Tyler Smith.
Tyler A. Smith from the Office of the Public Defender here in Ingham County. I do appear on behalf of Mr. Ruiz, who's appearing separately via Zoom today.
And sir, you are Joseph Ruiz, is that correct?
Yes, sir.
Is it pronounced Ruiz or Reese?
Reese.
Reese. Thank you. All right, this is the time set for a final pretrial in the matter. Mr. Smith, how are we proceeding?
Your Honor, at this time, the people move to dismiss. Defense counsel has provided me with pictures of repairs that Mr. Ruiz has made to his fence, of the portion of the fence where it's alleged that the dogs were able to get out. So based on defense counsel's representation and the pictures that I have received, the people are satisfied that the defendant has made the necessary changes to prevent his dog from getting out again. So at this time, we move to dismiss.
All right, and this has to do with the dog Prince and Rhea. Is that correct, Mr. Reese?
Yes.
All right. Anything on the dismissal, Mr. Tyler Smith?
Anything case specific? No, but I think this is kind of the main thrust of these types of charges, to get these things repaired and to save the public the hassle of dogs roaming at large. Certainly no objection. I don't make them further.
All right. Thank you, Mr. Smith. So I'll dismiss without prejudice for compliance purposes. These are both on a ticket. There are 2 counts on a ticket, so I'll dismiss the ticket. Anything else for the record in 26-01406 or 26-01390, Mr. Smith?
Nothing from the people, Your Honor.
Mr. Tyler Smith.
No, Your Honor, I should be good to go, Mr. Reese.
All right, you should be all set, Mr. Reese. Thank you for your appearance today.
All right. Thank you. Appreciate it.
Who are we calling next?
9 o'clock.
Got some 9 o'clock.
Taking over from my son.
Yeah, we'll make it done.
Oh,
All right, I'll give Mr. Smith some time to meet with Mr. Johnson, and then we'll come back. Let us know when you're ready.
Of course.
All rise.
thank you, Your Honor. I appreciate it.
So I have to do anything, just get that, take the clerk's on. This one, I'll show you.
Be seated.
That's the amended law. Stairs. Yeah, this one.
You're fine.
correctly on my house.
Oh,
No, most people say something else, so that's fine.
I actually had a professor who spoke a bunch of different languages with their age.
Yeah, I mean, if I spoke Arabic, and say my last name a little better, because there's a bit of a hard H at the end, but most people drop it.
Seems like pretty good. It's written.
It's a very poetic language. It's like very much lots of like simile and metaphor in the way that they speak, which is neat. Yeah, well, still a C.
I'm a little annoyed that my dad didn't teach me when I was a kid. He claims he tried.
You just turn on. You're like, guess what we're doing all day today? Brought you some beverages.
Yeah.
Yeah.
From my understanding, the best way to learn is just to get children's books.
Yep.
Yeah.
I do that with German, actually.
Yeah.
So I learned it in high school.
Yeah.
It's surprisingly difficult. So you
German is?
Well, children's stuff.
Sure.
Because kids learn lots of stuff, like slate, the mud. An adult has very little reason to know what the word for mud is.
Sure.
It's all this everyday stuff you never get
Yeah.
in academic context.
Okay.
But it's tremendous. All right, let's see if we got anybody. All right. CPA? You a CPA?
CPAs.
Take some accounting classes.
Oh, no, it's just my time sheet.
Oh,
I'm
shit.
getting paid for the prosecutor's office, I get paid for it.
Oh, okay. Got that office over by the firehouse?
I think that's where it is, but we were only there for training and we haven't been there since. And we're really old, so.
Yeah, they used to be the public defender building. They used to have an office.
I kind of remember that because I remember them saying that when we first got there, like.
It's ironic.
All right. It's all right, but it wasn't great for training, you know,
You know, it's not the best building.
especially with a couple bathrooms and you've got 30 people there and you've got some stalls.
Really? They had single?
Well, it's not even single stalls, it's just a single bathroom that locks.
Really?
Yeah, they have two on the first floor, two on the upper floor, like men and women, so it's just a single toilet.
You know, there's one in the basement too.
They did not tell us that. And
It's
they
done.
want us using that apparently.
It's special.
I'll let people back. So we need to-
Cockroaches the size of a cell phone. Length. But there's a toilet down there.
Right.
James, did you?
Harry's is, Harry's one of the. He's got several
Oh,
cases.
are you ready?
I think, are you ready on Mendenhall?
I am ready on the, he's taking the offer on the asset. Immediate sentences today.
Let me take,
I'll give you a couple minutes.
yes, thank you.
guess 9 o'clock, Mr. Graves?
Looks like it. Somebody it's trying to talk, right?
Trying to keep the- it's all busy. Don't look like it's the biggest stuff.
He said something about my reputation.
Yeah.
I don't know.
Meant by that,
Yeah,
but
I don't know if that was an, I don't know if that's an insult or.
Well, depending on what your reputation is, I don't know.
Yeah, I mean, I don't know what that's.
Get a reputation for being named Dan, but,
I think we all heard that. We were like, wait, what?
yeah, I heard that. I was like, well,
What do you mean by that?
what just happened out here? Jesus.
Possible shots fired.
No, you got it.
We like to speak to the client.
Sure. So what do I need to do with the client?
Basically just going over the factual basis, going over the police report, getting their side of the story. If they have any, statements they can give, and then strong thing, like saying for final pre-trial, they see.
I mean, it's- regardless of what the offer is, it'll be better dismissal. So that's what I want set. That's a number one. Let's do two.
Wait, I missed that.
We're here for pre-trial.
Yeah.
If the witness doesn't show up at final, it's a dismissal. So they could say, hey, 76948, all the bells and whistles.
Yeah.
Rose yogurt, everything. You don't give a shit. We want to dismiss. Okay. No matter what they say.
It's basically a situation where I had. It's almost like in some cases, it's almost always connected because at that time.
I can tell, dude, seemed
You're not
pretty
gonna
chill.
have when it's shop is gonna show up and it's
He's not in the same
position.
Yeah.
Yeah.
Well, you know,
Damn,
it
46.
was 4th of July yesterday, so maybe he's just, well, not yesterday.
Well, no,
Maybe he's just considering the,
Continuing the success that we do.
you know, the best,
So.
the best thing for hangovers.
You know, I drink.
Continue drinking, so he drank on the 4th of July, and I'm like, okay, cool. Well, I will just keep drinking.
It's the offer.
Gotta do these. Dog license and dog large.
Let me go over there.
I don't know.
You're probably not right.
I mean,
That's low.
It's basically just getting emotion from the dog and guilty. And
Well, I mean, it seems
you know, to young to find something.
So how do I know what the offer is?
Yes, Dan, very well.
Okay.
Sometimes they'll send an email with the offer plan, sometimes they won't. Hey, is there an offer? Here's the doc.
Now,
It's my
the chain of like, I need to get the side of the story. I need to tell them.
Basically, what I do when I'm doing this is basically.
Is that a good reputation
Or
for
do you have
that?
a different story you want to, or do you want to provide your
I
side of the
have
story?
no comment. I'm Switzerland.
Oh, so it must be bad.
Are we ready on, are we ready?
I think.
I'm ready on,
Yeah, we'll ask for German, we're ready on.
he's ready.
Yes,
Oh,
we're-
kill
ready
it.
on like one
Okay.
thing.
yes, we're ready.
On a couple?
Yes.
Okay.
Sure.
It must be bad.
Wanna ask if there's an offer, you can. No, so you don't-
They'll probably say like,
You might say if there's an offer, fine.
There's a client.
That's fine.
I mean, the good news is, I suppose, that if you don't.
Yeah, you can file here, that's probably not gonna be on support and all that.
Okay.
Can you grab, can I?
Dog and beauty, dog license, dog collection, dog warrant. It's gonna probably emotional.
Can I? Schaefer.
He's just sitting on the benches.
Yeah.
Be comfortable with asking for a final pre-trial motion. It's really scheduling there. So I just want to get you on the record on something.
It's a dog. It's his
Oh, no.
on my schedule to change.
Monica, do I need you to start?
No, you just have them come in.
Oh, that's fine. That's fine. Yeah, it's true. Actually, I don't need no more. I'm just waiting to see if they gonna have
Payment due for the window?
Yes.
That's what they're gonna do with this building.
I think area is supposed to be a hotel.
So they keep hearing, but they also keep hearing other stuff. So
I don't know. They can shut it down today after Friday. That heat wave we got in here Friday was horrible. It was bad. We had the doors open, courtroom fans on, and nothing circulated at all. I don't know, I didn't want to start on the elevator and everything else is falling apart.
Oh, yeah. That's just they just delaying everything until the new building's been built in the last 3 years.
And I guess the building's like, okay, show you, start falling apart before you.
Just waiting for the flags, the locusts and shit.
Yeah, yeah, that's. Well, shoot.
Maybe it's roaches, not locusts here.
Like the bathroom, we shut down for almost 2 weeks. I guess it was some flood down information or numbers. It just can't get worse.
It's a dangerous thing to say.
I know, that's scary. I know, especially here. I don't know, but that's last I heard. Jill, but I think there's a date. They expect us to be out here, so I know that's gonna work. And I think it's before we're supposed to be good. Yeah. To be interesting.
It's really commission to work out.
Oh,
They
yeah.
don't get paid enough for that.
Oh, no.
I bet it is a hotel. It's just a spot.
Gotta get some more stuff down.
Defender Day was not.
What are you gonna look at? You know, they saw me in bad shows. I drive through eat right sometimes. Downtown is just worse. Everything's everything. I'm like, this is the capital.
It's better than it used to be.
Oh, yeah.
I don't know if you heard stories.
Uh-oh.
It used to be up and down Michigan, any kind of goods and services you're looking for, you can probably find those.
That part.
Within sight of the Capitol.
Oh, yeah, like 28th Street, Grand Rapids.
Yeah.
Just
You
like
know.
that. Yes, just like that. Yeah.
So they come down on that a little bit.
Oh, yeah.
But
First shot. You get to a stop sign.
Are we ready on any free trial?
Where am I? Where am I?
I do remember being on Brightmoor like 10 or 15 years ago. It was especially bad down in Detroit. And I come up to this stop sign and there's half a couch in the intersection, not a whole couch. Just half a couch in the middle of the intersection. And I stop and people start coming up. It's like, nope,
Oh,
I am not sticking around right here.
no, I'm gonna run this red light. I'll take my chances with a ticket.
Yeah.
Yeah. No, it's bad.
It got a little better down in Brightmoor now.
Oh, okay, good.
It was during the bad time.
Yeah, I mean, once they get past these teen takeovers downtown, they're gonna be all right. Cause I honestly was gonna go this weekend. I'm like, well, the last takeover they had, they set the kids up. They had buses waiting for them. Took them all down to the jail, called the parents, find the parents the money for it, because the mayor told them, well, we got one more time to break her. We're just gonna start charging money. But it was like, but it was hundreds. So what happened was the mayor, they 769.
First I heard of it.
The mayor change it when the kids can bus rides. 'Cause they're not going to school, they can't get downtown Detroit.
All rise.
You be seated.
You ready?
I can admit this because they won't identify themselves. All right, on the Motorola Moto G, I just allowed you in the Zoom courtroom. Could you please identify yourself? On the Motorola Moto G cell phone, could you please identify yourself? Or we'll put you back in the waiting room.
I got you.
What's your name? I'm sorry, I can't. What's your name?
Timothy Trowbridge.
All right, we're gonna rename you and we'll call your case in a second. Rename it.
Yeah.
All right, Mr. Smith. And Mr. Johnson, that's your case, is that correct?
Yes, sir, Your Honor.
All right, so we're on the record in 26-01020. That's people of the state of Michigan versus Rachel Chillick. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, here on behalf of the people.
Mr. Johnson.
Good morning, man. Please, this honorable court, Kareem Johnson, on behalf of Ms. Chillick, who stands to my immediate right.
And ma'am, you are Rachel Chillick, is that correct?
Yes, Your Honor.
All right, thank you. This is the time set for a final pretrial in the matter. Mr. Smith, how are we proceeding?
Defer to defense counsel, Your Honor.
Mr. Johnson.
Yeah, the defense counsel is requesting an adjournment of the final pretrial. I think that it's fair to say we have a resolution on half the complaint. We're still trying to negotiate the other half of the complaint, Your Honor. So we'd be asking for a adjournment of the final pretrial, excuse me. And I'd like to address a bond issue.
All right, Mr. Smith.
The people agreed to an adjournment, defense counsel. We made another offer. We had some pretty encouraging negotiations about resolving the case. I believe maybe we can get the case resolved without a trial. So we would stipulate to an adjournment.
All right. So we are looking to adjourn the final pretrial at the request of the parties. And what's our time frame? What's the time frame on this?
Yeah,
I know you've got other cases scheduled. This isn't your only case.
I would ask for the 27th. That would work perfect for me, if the court's available that day.
How does July 27th look? Yeah.
Yep.
All right, 8:30. All right, we'll set it for final pretrial on July 27th at 8:30. And Mr. Johnson, did you want to be heard on modification of bond?
Yes, Your Honor. A situation has arisen. I have spoken to a CPS agent and Mr. Smith regarding, I believe, a dental appointment and enrolling the children in various schools, including some in the Genesee County area. I think it's been requested that a power of attorney be signed by my client, allowing for her mother and I guess her brother to do so. I mean, at this point, my client's not comfortable doing that. We're asking the court to consider allowing or amending the no contact order of the bond to allow her to be present for medical appointments and to enroll the children in the various schools.
I have Eaton County CPS is involved. Is that correct?
Genesee County, whatever matter was at Eaton County, I think that was closed out. I spoke to a Genesee County agent, yeah.
So, Your Honor, just to give you an update, the children are currently with the defendant's mother and the defendant's brother. And they're having some some issues, getting the children enrolled in school, getting some medical treatment for the children. Again, the defendant has declined to sign the power of attorney. That's within her right. I let the complaining witnesses, the grandmother and the brother know that they'd have to seek civil remedies in order to fix that portion of the case. But at this time, Your Honor, due to the nature of the allegations and all of the information that's contained in that Eaton County Children's Services report, the people would oppose any amendment to the bond with regards to the defendant having contact with the children. There's some pretty serious allegations in there.
Yeah.
So until that's resolved, I'd ask the court to keep the bond in place.
Mr. Johnson.
Yeah, we're not asking for, her to be alone with the children. The children have a dental appointment. We're just asking that my client be allowed to show up at the office and take care of whatever needs to be taken care of. She has not had her custody rights either suspended or terminated by the family court. This is a voluntary arrangement that has happened between the families.
She's under no contact order that this.
From this court, yeah, from this court.
She was arraigned on June 1st.
That is correct, Your Honor. So the family court, the court who had jurisdiction to either temporarily or permanently suspend her parenting rights chose not to do so. And we understand that this court has a different opinion and it has different issues that it has to look at. And no contact order is typical in this type of case. We're not arguing that it is not. But because she is still the legal caregiver for these children, we'd ask the court to consider what would essentially be supervised contact for the sole purpose of enrolling in school and medical treatment.
Thank you. Based on the 2 counts of child abuse that are the allegations at this point, I'm going to deny the modification of bond request. My concern is for the 2 counts to go forward. We're adjourning the final pretrial to July 27th at 8:30, and I'm going to deny the modification of bond and continue the no contact order. Anything else for the record in 26-01020, Mr. Smith?
Nothing from the people, Your Honor.
Mr. Johnson.
Nothing from the defense, Your Honor.
All right, we will see you on July 27th at 8:30. Thank you, Mr. Who did you want to go on? We have
Mendenhall.
Menden. Mr. Gonzalez, that's you. That's Harris Mendenhall.
She's pretty good.
Right, is that a Mr.
Oh, okay.
Is that a Mr. Smith or Mr. Harris or Mr. Raba?
Mr. Smith.
All right.
Mendenhall.
Well, that's Mr. Harris.
Okay.
I believe
I thought it was.
he's ready to go, or
He's speaking with the client outside.
just play one up.
You want me to grab him?
We can bust in on that. Okay. Joe's ready to go.
That's notice. Yeah. Only thing on the front is just. No, that's just your notice. Yeah, notice you just date and sign it. Yep. Yep, just date. And check personal service. Oh.
He said, what did he say?
He'll be in a minute.
What else? Were you ready? Were you ready on?
Are you ready on one? So you're supposed to, or no, you weren't doing one.
I was just talking. I was
Using Mr. Harris' case.
Do we have any 9 o'clocks that are ready?
I think Trowbridge is pro se.
Is the courtroom?
You might need to talk to Trowbridge. Yeah.
I accidentally had.
Other than that, I think we've got some ready.
Flores.
And so when
Flores, no? What case did you ask me about?
I asked you about Mr. Haynes.
You're not ready on that one?
This courtroom 3, we can.
I was just speaking with the client when I asked you that. I'm not sure who's handling that.
I see it in the main
Says it
section,
here.
but. Yeah, it just still shows up. I didn't know.
Do they want to talk to you?
That's good.
It is in room one, but I haven't joined room one. I'm assuming I'm the only one who can.
I don't know if that makes a difference.
I-
It looks like it's in the main section.
Not just a moment, like,
Yeah,
we have like, I think 3 or 4 cases. I think 3 or 4 cases. They took.
One.
I was seeking time.
and I see we have the translator here also. Did you want to go on Ms. Suarez
Uh,
Are you ready?
Yes.
or
I'm ready on
Mendenhall?
Mendenhall, I'm ready on Suarez, and I'm
Okay.
ready on Mr. Haynes.
All right, let's go on Mendenhall. All right, so we're on the record in 26-00275. That is People of the State of Michigan versus Paris Mendenhall. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith here on behalf of the people.
And Mr. Harris.
Yes, Your Honor. Assistant Public Defender James Harris here on behalf of Ms. Mendenhall, who appears via Zoom. She does apologize for being here via Zoom instead of in person, Your Honor. She had my understanding is she had a ride set up, but that ride fell through pretty late this morning. She contacted me regarding what to do because she did not want to get in trouble with the court for not appearing in person as ordered. I indicated to her that if she can't appear in person because that ride fell through, appearing via Zoom would still be better than not appearing at all.
All right. And ma'am, you are Paris Mendenhall, is that correct?
Yes, Your Honor.
All right, thank you. This is time set for a final pretrial in the matter. Mr. Smith, how are we proceeding?
Thank you, Your Honor. At this time, it's my understanding that the defendant is going to plead guilty in this case with an agreement to pay restitution to Mr. Stephen Tamaka in the amount of $86.03.
All right, we should just set this for plea. Don't you think?
I believe with the video, she would be able to handle.
Yeah, but I'm uncomfortable with taking it per video, and Ms. Mendenhall should be here to plead guilty. Yeah, and that would suffice for the final pretrial, I would think. So we should just set it for plea, especially if restitution's involved.
Yes, I believe we already know the amount of restitution, and that amount is not being disputed, Your Honor.
But I think restitution becomes easier when done in person. So, so Ms. Mendenhall, we're going to set this for plea. And you should be live in person on the 6th floor City Hall of Lansing, and we'll set it for the plea date of, I would think 2 weeks would be sufficient. I have several failed to appear from Ms. Mendenhall, so I want to make sure that.
Understood.
Yeah, she's, I have a failed to appear on March 9th. I have a failed to appear on April 20th. So I have 2 prior failed to appears. I want to make sure that she's here to, for the restitution claim and for the plea to the MDOP. Or whatever, what is the plea?
I believe it would be a plea to a disorderly person with a promise to pay restitution and a killer agreement to not from jail. I would leave that to be.
Yeah, I'll let that agreement, you can provide the court with a copy of the agreement. But we'll set for plea on July 20th at 11 o'clock. All right, so Ms. Mendenhall, we've set this for July 20th at 11 o'clock. We've set this for plea. That'll be live in person on the 6th floor City Hall of Lansing. All right, ma'am?
Yep.
All right. Anything else for the record in 26-00275, Mr. Smith?
Your Honor, I just want to place on the record the appearance of the complaining witness, Stephen Tamaka. Is that how you pronounce your last name? Oh, Tamaka. He is present in court. I ask that you waive any of his future appearances.
All right. You should not be needed at the plea date. So we're gonna waive the appearance, the prosecutor won't be subpoenaed. If it is set for trial, you'll get a subpoena, okay? All right, is that a fair statement, Mr. Smith?
Yes, Your Honor.
All right, Mr. Harris?
Yes, Your Honor.
All right. All right, I'm gonna indicate that you will not be subpoenaed for the plea. All right. Lost Miss Mendenhall. So I'm setting this for July 20th at 11 o'clock. You should be all set. Thank you for your appearance today. And Mr. Harris, you can let Miss Mendenhall know the date and time.
Understood, Your Honor.
All right. Are you ready on Suarez, did you say?
I am ready on Ms. Suarez, Your Honor.
All right, Maydelis Suarez. And I'll have the interpreter indicate her first and last name and spell them both for the record.
Norma Baptista, Norma Baptista.
Please raise your right hand, ma'am. Do you solemnly swear affirm that you will truly, accurately, and impartially interpret in the matter now before the court and not divulge confidential communications, so if you got under the penalty of perjury? All right. All right, Ms. Baptista, just let me know if I get going a little fast.
Thank you.
All right, so we're on the record in 26-01250. That is people of the state of Michigan versus Maydelis Suarez. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court. Assistant Prosecuting Attorney Dan Smith here on behalf of the people.
Mr. Harris.
Assistant Public Defender James Harris for Ms. Suarez.
And ma'am, you are Maydelis Suarez. That's a yes? Okay, thank you. This time set for a pretrial in the matter. Mr. Smith, how are we proceeding?
Yeah, we're just waiting for the interpreter. The people requested this matter be set for a final pretrial.
Defense would also request a final pretrial date at this time as negotiations continue.
All right. So set for final pretrial for July 20th at 8:30. We will need a Spanish interpreter. So we've set it for July 20th at 8:30 for final pretrial, and you should get some notice from my court officer. Anything else for the record in 26-01250, Mr. Smith?
Nothing from the people, Your Honor.
Mr. Harris.
Nothing from the defense, Your Honor.
All right, Ms. Suarez, we'll see you on July 20th at 8:30. And thank you for your assistance today, man. You should be all set on that file. Both of, I don't know, Mr. Trowbridge is represented.
Trowbridge is unrepresented.
He's unrepresented. So we'll just place that on the record on Mr. Trowbridge. And then Mr. Anderson is here.
Anderson, I would need to speak with briefly, Your Honor, but I am ready to go on Jaden Haynes.
On Jaden Haynes?
Yes, which
All right.
Mr. Rabat would be handling.
All right, let's call Mr. Haynes and then we'll put you in a breakout room with Mr. Anderson. Mr. Anderson, we're going to place you in room 3, and then your public defender will be in there in just a second. All right, so we're on the record in docket 2601-639. That is People of the State of Michigan versus Jaden Haynes. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Mr. Harris.
Yes, Your Honor, Assistant Public Defender James Harris here on behalf of Mr. Haynes, and I also have Mr. Rabat from our office.
And Mr. Rabat, this is your, is that okay? So, Mr. Rabat, your appearance for the record.
Student Attorney Alex Rabat for the Office of Public Defender representing Mr. Jaden Haynes.
All right, and sir, you are Jaden Haynes, is that correct? Yes. All right, thank you. This is time set for pretrial in the matter. Mr. Smith, how are we proceeding?
Thank you, Your Honor. At this time, the people requested this matter be set for a final pretrial. My understanding that the negotiations are going to continue. The people have conveyed an offer. Need to give the defendant time to review that.
All right, Mr. Rabat, is that a fair statement?
Yes, sir.
All right, so we'll set for final pretrial for July 20th at 8:30. All right, we've set this matter of 2601-639 for final pretrial on July 20th at 8:30. Anything else for the record in docket 2601-639, Mr. Smith?
Nothing from the people, Your Honor.
Mr. Rabat.
Nothing from the defense, Your Honor.
All right, Mr. Haynes, we'll see you on July 20th at 8:30. You should get a notice to appear for my court officer. Thank you.
You wanna?
And then, Mr. Harris, did you want to see Mr. Anderson?
Yes, Your Honor.
You're in room 2. I'm gonna put him in room 3, and then you can just join in. That should work.
And did you want to put the
Mr. Trowbridge? Yeah. All right, Mr. Trowbridge, we'll call your case.
Pardon me?
So we're on the record in 2601-500 and 2601-501. That is People of the State of Michigan versus Timothy Trowbridge. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
And sir, you are Timothy Trowbridge, is that correct?
Yes, sir.
And you can hear me all right, Mr. Trowbridge?
Yes.
All right. This is the time set for a final pretrial in the matter. Mr. Trowbridge, you are not represented by counsel at this pretrial, is that correct?
Yes.
Okay. Did you want to meet with Mr. Trowbridge, or did you just want to make a record, Mr. Smith?
We could just make a record, Your
Okay.
Honor, to keep things moving along here today. Mr. Trowbridge, this is actually the time that's set for just a pretrial, Your Honor. On looks like Mr. Trowbridge is charged with 2 dog at larges. And typically in these cases, if repairs are made in order to ensure that his dogs will not get out again, we typically would dismiss these cases. Mr. Trowbridge, if he's not represented by counsel, he can reach out to our office, provide me with the adequate pictures to let me know that changes have been made, and we will dismiss the case. So you could just reach out to me at the prosecutor's office if you have that information, Mr. Trowbridge.
And then did you just want this reset for pretrial, or did you want this moved on to final pretrial?
Your Honor, we can set for a final pretrial.
Okay. And Mr. Trowbridge, you understand that to contact the Ingham County Prosecutor's Office, Mr. Smith would be the contact person at the prosecutor's office.
Yes, I do, Your Honor.
All right. And this involves the dogs Reba and Cash. Is that correct, sir?
Yes.
All right. All right. Let's set for final pretrial. How many weeks do we need on this one?
Give them 4 weeks.
4 weeks. Okay. Beginning of August sometime. Okay. We'll set for August 3rd at 8:30 for final pretrial. Third at 8:30 for final pretrial. All right, we've set for final pretrial on August 3rd at 8:30, and Mr. Trowbridge, you can keep in contact with the prosecutor's office in relation to these files, and Mr. Smith will let us know if we need to keep that date. But
Yes,
we've
sir.
set it for August 3rd at 8:30. Anything else for the record in 2601501 or 2601500, Mr. Smith?
Another from the people, Your Honor.
Mr. Trowbridge, do you have any questions of me?
No, I don't, Your Honor.
All right, you should be all set, sir. Thank you for your appearance today.
Yes, thank you. Goodbye.
You have Anderson and Mr. Harry's is meeting with Mr. Anderson. So just let me know when that's
Yes.
all ready.
Yes, Your Honor.
All rise.
So.
May be seated.
Yeah, other than being insulted. Sure.
Not technically confirmed it was controlled.
Not technically.
Totally fine.
Yes. It's true. So. we got some crazy- You with me this Thursday? Got some crazy shit. Let me look up.
Just put mail to the, yeah, just put mail in there. Yep, today's date. And that's it. And same with the other one. Mhm. Oh, shit. You get to hang on, get ICs because it's basically the same. Like last week, the same repetition from last week. Yeah. Just a smaller document. But just remember the notes. Your notices always go 100-hour way. Knowledge. Prosecutor first, judge signs it. Acquittals, judge signs it. And signs it. For the probation, like earlier, he was taking out probation with the file. And as I was unexpected, if you have to modify a bond, PA-53 is because you got to do so many of them. Like you said, you got to do 4 copies. So you got to amend it, then you make them wait because I don't let them leave or I'll give the copy because they can't say, well, I didn't know, Judge, you didn't tell me I wasn't supposed to go in person. I mean, I do it for our own personal benefit. So you can't say, well, Judge, I didn't know. Or even sometimes with tether place, they like to see it, but just make sure they get. And I make them wait because my thing is especially for something that benefits them. If I'm amending your bond, then at least you can do is wait till I get it done. And they usually don't get no problem on it. That's pretty much it, man. Like I said, just get used to the repetition. On the day, the final pretrial is a ton of dismissals, adjournments. But it's just the same thing. It's like literally, it's every week you have some days like today is a different contrast from last week. But you have it like that. Some days it's like this. And some days it was like all last week where every day was people jam packed all day. But it's the same principle is line your people up, stay in the face with the attorneys, you know, get status updates on what's going on. You become comfortable, man. I mean, like I said, this is kind of the first day on the throne, but it you know, what I say is, you know, take your time with details.
Scroll on that side. Yes, you do have access to it.
When we pulled it up in there, he had access to it, but when I actually clicked on it, there was no emails there, like the roster from this morning wasn't there. I mean, you
It
see it
is.
there now?
Oh, it's in the,
It's in there.
Okay, it wasn't there earlier, so
that's the
weird.
judge's courtroom.
yeah. That's why I sent the whole email in the beginning, because I was like, I was gonna have him work on the roster thing. And when we went there, I'm like, crap. he
So
doesn't
you're
have
saying
it.
in the office, he doesn't
Yeah.
have it? Can you come with me?
Yeah.
If, can I
But
take him
maybe
real quick?
it's, yeah, maybe it's just different.
Because you should have it in wherever you're at, you should be able to have. Can we go
Right.
do it there?
Yeah.
Okay. David, thank you.
David, this
Yeah.
afternoon,
Yes, ma'am.
Culberson and Shabazz, they are our jailbirds.
Oh,
Judge has said that they're gonna remain in jail.
oh, that's one.
So I just wanted to give you a heads up.
Okay. Appreciate it. I think once I told him is don't let it overwhelm you. It's that you're not gonna get this all in one day, 1 month, 2 months. It'll take a while
Yeah.
if you've never done this before. But the main key is repetition.
Yeah.
Notices, you know, much more or less. Today was an exception to the rule because you get a bond amendment, which is rare. You get them like that. But like I told him, just take one day, just take time.
Okay, because you guys just clicked, there's an arrow that is up. You have to click the arrow down and then it'll show all the mailboxes because he had it.
Oh, he did. Okay, I didn't see it this morning, so, okay.
No, it's because that's what I'm saying. You can't
Yeah.
just click on the name, where it says, whatever it says, Judge Flores' courtroom, I don't know what it says. You had to click on the arrow and the arrow would have gone down and it would have released the
Okay.
folders in that box, in that email
I'm
address.
following you.
Okay. All right.
You're very sunny today.
Oh, I hope that's a good thing.
It is a good thing.
Good. Thanks again, David, appreciate it.
Thank you, Markeisha.
You're welcome. You guys have a great day.
You as well.
All right.
But and then if you have to, you know, say, hey, judge is good with it. I just needed like a quick second to catch up. And he'll do it. I mean, because you want to get it done, but you want to be efficient as well. You don't want to second guess yourself. So that's why a lot of times I don't let people hover. Like when I just said, notice, hey, go have a seat, because I don't like being micromanaged. So I don't like people standing over when I'm trying to get their paperwork and stuff. Just go have a seat. Give a minute, I'll bring it back to you. Plus, it keeps in the safe zone. I don't like people hovering around here. Even the defendants, even if they get something dismissed, still don't like people hanging around. It gives you time to say, okay, there's no pressure. I might stand over me when I'm trying to give them their notice, get it to them. A lot of times you see the attorney hand it to them as well. And it gets hectic, but you just, again, you pace yourself, you know, and they're waiting on you. I mean, they literally have to wait for you. So whether it's me giving you a notice, a copy of dismissal, a copy of bond, or taking you downstairs, they have to wait on you. So, I mean, I say it in a way that's customer friendly, but there's times like, hey, listen, give me a minute. And like I had the one attorney Thursday went so high. she's hovering, like, yeah, I need this. I'm like, you see how many people I got on my diet? You know, I'm not trying to say it nicely. You just hold tight because I gotta make sure this other stuff is done. I mean, all the people we had in jail was insane. I mean, that's not normal. So in those cases, you see, I'm not being rushed. We'll get to one matter we can. I can't, I would like to be everybody. I can't.
Yeah.
And especially her, I mean, literally,
That's.
I'm about to maybe you trying to mine. So if nothing else, I wants to raise it like that. I didn't think I was gonna miss that guy. That he gonna raise his phone. I was like, so just to face it. We just want to get started. You know, if it comes to it, I'm ready to start over again.
It's up to them whether we start with that next fight, the next, three
Court's
calls.
off.
Still.
No, I mean, there's nothing, unless you are doing a bond, they just get the files. You have to, the only time you do paperwork, easiest way, only time you have to do paperwork is non-living bonds. Or, you know, Marcy asked you, so, yeah, can you put out a notice, somebody to notice. But no, once you get everything in there, you know, I double check the ROA to see what goes where and then just drop them off. Drop them off. Sometimes. Yeah.
It's a good side thing.
Yeah, if you, so. And you might want to, I mean, however you want to do your cheat sheet, you know, you can even, sticky notes is your best friend. Yeah. Trust me.
Oh, yeah.
I had sticky notes. Once I got accustomed, I put them off. But I write my sticky notes. Nollies, ACQs or acquittals, but nollies, ACQs.
It's not,
Nollie, prosecutor, judge, defendant, ACQ,
it's
judge,
It's the same.
and the defendant. So knowledge is,
They don't get.
knowledge is the prosecutor, judge, and the defendant.
I don't know.
So yeah, so prosecutor, judge,
Michigan according to court rules.
then the defendant.
Civil ship is important procedurally. Yeah. Criminal justice system different.
Your
But.
is acquittals, which are basically the submission, but your acquittals, which I'm trying to find. So
Yeah.
it's just, it's the judge and then the defendant.
Yeah. So it's not rare, but it is. It's a practical situation. Yeah.
Oh, no.
Not necessarily helpful for us. I'm sure very helpful.
Yeah.
Yeah.
This one. The acquittals, because most of you always put them in front of the file.
Is somebody meeting with Anderson? What's going on?
No, Ryan finished meeting with Anderson. I'm
You
just
did?
waiting for Dan to get back. to talk to him real quick.
See, now we're waiting
Well,
on him.
somebody knock on the door. He's the last thing, right?
Yeah, can we, go conference table?
Want me to stir him up?
Yeah.
All right.
Bro, like, that's when it's hot. Blessed today, it ain't hot like it was Thursday.
Yeah.
Clients get upset, like, I'm still sitting here in the meeting room.
Somebody was really mad about that last week.
What's that?
He came in here and, he wasn't heard until the end of the morning docket, and he was annoyed about, his parking meter.
Yeah. Oh, Anderson?
Yeah. Just want to get it.
Can't do anything for you.
Does he have the? Yo.
Does have licenses.
Yeah, so knowledge,
In Bremen.
knowledge go in the front and, yep, just like that.
6/20, 2027.
So do the acquittals. So that's one. Basically same thing, different language. So acquittals in front, knowledge in front. Basically both.
Which are the two dogs. And is the dog MDOP that would be set for a final that I'm potentially. gonna be,
Sticky notes
likely
are
to
down.
send in a motion.
Okay, we're ready.
Wonderful tool. I'm telling you, because once Megan got comfortable with certain things, she just brought certain ones off. Like she had maybe because of the heat of the moment, just hey, okay, just go here, just go here. So, and I still got some myself on here. So, no, no. Especially for something that's gonna be on the fly. It's like right here.
Get to see
Okay,
the more
now,
beings. Very reckless with company.
and then
I don't think he's
Probation?
ever set that computer somewhere where it's
Yeah, it was
completely on top of
sticky,
something. It's always hanging off the edge.
here,
Yep.
the key words is refer
Hey, if
to
it balances, it
probation.
balances.
Here it just says, I'm referring you down.
And this
If
way
you
it
almost
gives you,
dropped it,
gives
I didn't
it-
want it.
this way it gives it the
Refer to
perfect,
probation slash
perfect reach for my
PSI.
fingers, so I don't have to bend over or hunch to anything.
Yep, refer to probation in slash PSI.
Places to laugh at.
God, I wish.
That's right.
Is that one
See,
of the
Tyler,
apartment
that would imply I have anything in my office.
Yeah, that's true.
Is your?
All right.
My office is full. My office. Stuff to the
Can
brim.
be seated.
I don't even have enough space for all of it.
Yeah.
All right, this
It's
is
not exactly
Jonathan
what I
Anderson.
buy For the office.
Can I call these files together, Mr. Smith?
Yes, Your Honor.
All right,
I would also request to be called together.
all right. All right, so we're on the record in docket 26-01537, 26-01538, 26-01539. That is people of the state of Michigan versus Jonathan Anderson. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, here on behalf of the people.
Mr. Harris.
This is actually going to be handled by Ms. Rawls, Your Honor.
And how do you spell your last name, ma'am?
It's Rawls, RAWLS, first name Linda, Assistant Public Defender, appearing on behalf of the defendant, Jonathan Anderson, who's appearing via Zoom.
And you're new to the Public Defender's Office?
Yes, I am, Your Honor. P number 72190.
All right, and sir, you are, so welcome, Ms. Rawls. Sir, you are John Anderson, is that correct?
Yes.
All right. And you can hear me all right, Mr. Anderson?
Yes, sir.
All right, thank you. This is the time it's set for 3 files in the matter set for pretrial today. Mr. Smith, how are we proceeding?
Thank you, Your Honor. At this time, the people are going to move to dismiss file number 01537 and 01538. After speaking with defense counsel has provided me with information that the defendant has recently gotten his dog's license, and he also has a vaccination certificate that was just done here recently. So because he is now come into compliance, we will be dismissing again, that's 01537 and 01538.
And is that a fair statement, Ms. Rawls?
Yes, it is, Your Honor.
So we'll move to dismiss 1537 and 1538 for compliance purposes. And then how are we proceeding on 26015339, Mr. Smith?
I ask that that matter be set for a final pretrial, Your Honor.
All right, and is that a fair statement, Ms. Rawls?
It is, Your Honor, but we'd like to advise the court and the prosecutor that we intend to file a motion.
Yes, Your Honor, given that this is a dog MDOP case, my office is likely going to be filing a motion on that. I believe it's the same motion this court has heard before. We would simply request that the motion be scheduled on the same day as the final pretrial.
All right.
And also James Harris from the Ingham County Public Defender's Office.
All right, and so, so I'll set the motion for the same time as the final pretrial, and about how far, what's this? But
I would leave that up to the court's panel.
so at least 2 weeks, but at least 2 weeks for subpoenas.
Yes, we asked for 3 weeks, Your
All
Honor.
right, so we'll put it in the vicinity of 3 weeks for final pretrial and motion. July 27th at 8:30 for final pretrial and motion to be heard.
This is 139, perfect.
Yeah, yes, 26015339. All right, so on 26015337 and 38, we've dismissed, and I think that those are all written on it. Are those on a ticket or on a complaint? I think it's a
I think
ticket.
the dog license ones would be on a ticket.
Yeah. All right, so those are both on a ticket, and then we've set the MD, the 26015339, which is the malicious destruction of property involving a dog, for July 27th at 8:30, and we've set the motion for the same time. Anything else for the record in 26015339 or the accompanying 537 or 38, Mr. Smith?
Nothing from the people, Your Honor.
Ms. Rawls.
Nothing, Your Honor.
All right, we were all set on those 3 files. Thank you, everybody, for your appearance.
Thanks.
So that one, I'll send a ticket, so we'll have to, we just have to take it.
All right. We have a couple of sentences this afternoon.
It's 1:30, and I think we have a.
Yeah.
Do we have a
We have a,
final pretrial for a domestic?
yeah, we have a final pretrial for a domestic on Emmerich. Mr. Harris, you're here, so you're here this afternoon.
Yes, Your Honor, I'll be back this afternoon.
All right, and then we do have 2 sentences, and then do you know if Ms. Donnelly, or are you covering the Rogers case?
My thought might be Miss Donnelly. I
All
do
right.
see it on her schedule, and I did see notes about it.
got-
So my guess is that she will be here.
Yeah, that's the only one I had any question. Ms. Culberson and
We gotta
Ms.
find it.
Shabazz are both
Check the case number.
incarcerated, I think. Okay.
Disregard
All right.
this.
All right, we'll see everybody this afternoon.
Thank you, Your Honor.
Okay.
Disregard this minute. So these are discussions.
Since one of your.
So that was the chair.
No, not during instructions.
Same motion.
All rise.
Yeah.
Next move, we just files everyone but
And I gotta go work on my jail warrant list for tomorrow. So no superior, you just kind of the same. I mean, it's up to you if you want to write a sticky note, but
Just nice sentence for me.
no superior, one goes in the file, one to the defendant.
Screen on for sale. We should-
Then you initial date, and then you just put if it's, you put what type of service. If it's personal, you check the box. If it's mail, you write mail. So no superior, notice to appear, one file, one to the defendant, or maybe one to the attorney as well, depending. They got a hired counsel. As soon as you get it, you
What's good from it?
want to the defendant, one in the file.
Is Judge Simmons in today?
This afternoon.
Did she tell you her husband was a juror on one of my cases?
And I understand why, I was trying to figure out why he sat there so long. Like, why?
So he told everyone, he was like,
Yeah.
hey, that's my, but yeah,
I'm like, what in the world?
And Nid missed it. Defense attorney didn't realize that he was a judge's husband.
Yeah, cause I'm like, why is he still here? Clearly, he gotta get booted
all
off.
so these two, Davis and from the file, I need to do.
Nope.
I have to go over to the public.
Goes under the ROA and that's it.
And meet with the victim on that. Remember the Crumley guy that who did the,
I remember
so she's in custody. She's in Ingham County Jail on a probation violation. So I have to go over and talk to her tonight at the jail. So you don't have to do that one. And then Davis, I need to talk to her, that individual separately. But everyone else, can you call them and take a look at how to call them?
Depending on what is going on with the rest of this week. Make sure they're gonna show up, just get them on this Thursday.
Right.
If
Just
just call. Could I be able to do more of this? You know, just need a space to do things.
Oh, actually, I mean, that's kind of my MO this week is I'm just shadowing.
Okay. I know
You gotta get
tomorrow I'm
comfortable
in the
doing
office
stuff,
all
so
day, so
I'm not,
time to do that.
I mean, less like today with Saban, where I had to get that
I was
bond,
thinking,
get more comfortable, that had to be
just
done.
had to
But
think about that. Maybe she
with
was
that, I just gotta get down with, gotta get down with the minutes. But yeah, no, I'm
since I've been here, I haven't had a
hands
trial,
off.
but I haven't prepared.
Unless, like I
trial
said, it's something that
documents
just got to be done. I mean,
because,
but
because
you gotta get used
I'm
to.
always.
It's easy when you see me do it, kind of watching it, but now
I gotta go talk to
the
them.
fires is, okay, let me just, now you gotta grind it out, you know what I mean? So,
Busy, so.
So do you just need,
Okay,
so do you just need those
let's-
victims told basically by end of day today?
separate.
Okay, and then,
So we're gonna do this.
end of day today, for
So,
that, and then,
This is the
And
bond
then
that I
at some
did.
point,
oh, yes, and then the
Amendment.
jury, or the court documents.
One
So you
also
just wanna do that
jail,
tomorrow?
one
yeah, we're gonna do that tomorrow.
Okay.
I do this every time, so I know what your judge, I can't read, I ask you sometimes. So, I'm unsure. Court date, next action. I do this intentionally because sometimes it's dismissal. Move to dismiss. That's a move to dismiss.
How do you know it's like, what's it?
Right there, move to dismiss. You just look for the current date and what's after the date. It's, and it's, trust me, it gets worse than that sometimes. Get to, now it's hot knock stuff, court stuff. Dismissal. Clerk's office stuff, dismissal. Move to dismiss. Dismissal. And that's what that, when you list, I would take that, like when you're doing files, I would take your clipboard. Just so you know, when you get down and move to dismiss. Dismissal. Another adjournment, next action. Set for plea, next action. Set for final pretrial, next action, that's Marcy Street, file those, printed. Next action. I'm just looking for dates, August 5th, next action. I'll use the next action, so it goes into the files. This jail, clerk's office, the prosecutor, and so. And I like y'all. So Sean, stupid around. Then we got our Andy Danny Millings. Yeah. Zoe's not necessarily a big rush when you get back, March, so, man, as always, make sure you lock up.
may, this is Marcy Klinkshern. I had an appointment for 2 o'clock on Friday, this Friday, the 10th. I need to cancel and reschedule. We had a
All right, Ms. Robinson's here for Ms. Culberson. So we're on the record in docket 25-03647. That is People of the State of Michigan versus Keisha Culberson. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court assistant prosecutor Dan Smith appearing on behalf of the people of the state of Michigan.
Ms. Robinson.
Aaron Robinson, Assistant Public Defender for Ms. Culberson, who's standing to my right.
And ma'am, you are Takesha Culberson, is that correct?
Yes.
All right, thank you. This time set for sentencing in the matter. Mr. Smith, do you know of any further restitution that is not addressed in the pre-sentence report?
No, Your Honor, no further restitution has been brought to our office.
All right. And I don't see any restitution as a part of the file. Ms. Robinson, have you had the opportunity to go through the pre-sentence report with Ms. Culberson?
I have.
Yeah. Any additions, deletions, or corrections?
Not at this time.
All right. And so correct me if I'm wrong. I have, but see, this was done quite a while ago. I do have a credit. On February 4th, the defendant had a credit of 15 days and then has been incarcerated since then.
Correct. So she's been incarcerated since May 24th. And to today, that's 43 days. So I think she's at a total of 58.
Okay, 58 days. Perfect. All right. Have you, so besides the 58-day credit, any additions, deletions, or corrections?
No, Your Honor.
All right, allocution, Ms. Robinson.
Yes, Your Honor, we'd ask that you follow the recommendation, sentence Ms. Culberson to a term of 60 days in custody. She's also got another case going on in circuit court. Her plan is to hopefully get into a treatment program over there and work something out where she can focus on her case up there. As I said, she's already got 58 days in. I guess we don't want these cases to hold her back if she's focused on getting treatment up in circuit court. And it's likely that she'll probably be under supervision up there as well.
All right. Ms. Culberson, is there anything you'd like to say to the court before the court passes sentence?
Yes, I will.
Go ahead.
I would like to start by owning up to what I did. I fully acknowledge what I did, Your Honor, at the time. I might have been going through something, but I have since then learned my lesson, and I did acknowledge to my lawyer that I knew that I really tried to get probation and I wanted the best, and I did hear everything you said, and I still want to work on myself, and I have gotten better with my addiction in my life. And, I haven't really been doing anything since then. I felt like I learned my lesson, and I wanted to ask for, and I wanted to apologize to the victims that it won't happen again, Your Honor, because I don't want to go to prison or be back in jail. And I just want to get my life on the right track, Your Honor. If I could get a PR bond and try and serve.
I don't think your problem is with this case. I think it's going to be with another case because you've got a lot of time in on this case. Okay, you've got 58 days. It is a 1 year. You pled to a 1 year, but you've got the recommendation is right around. I mean, it's right around that time. It's the other case that's probably holding that's going to keep you incarcerated.
I'm sorry. Is it the bond? Did you put a hold on that bond, or is it possible that I can get PR to rehab because cats?
I don't know. I don't know anything about the other file.
That's the case that's in circuit, so that will have to be addressed in circuit.
Yeah.
Okay. We're addressing the cases that are in front of you right now.
So you may or may not be a PR bond, but that's probably in front of whatever judge you have in circuit court.
Right.
Mr. Smith, is there anything you'd like to see on the case before the court passes sentence?
No, the people ask that you follow the recommendation, Your Honor.
All right, I am going to follow the recommendation by the probation agent. Sentence the defendant to 60 days in jail, credit given for 58 previously served. So the defendant is to spend 60 days in jail and credits giving for 58 days previously served. I'm not placing the defendant on probation. So there'd be no probation. It's 2 days. It's 2 days on this file is what there is additional 2 days. And you have 58 days in and they're asking for 60 days. Okay. The fines and costs on this file with another case ongoing, I'm going to set fines at on count 1, which is the attempt RNO, $200 fine, $200 cost, crime victims' rights fee of $75, state fee of $50 for a total of $525. And then on count 2, $200 fine, $200 cost. I'm gonna waive the state minimum course cost fee. And the crime victims' rights fee is $75. That'll be for $475. So the grand total, once you're able to pay, and we'll put this out
I
a
know,
while.
I pay it 25 every month.
All right, 525 plus 475 is $1,000 even.
Okay.
All right, and then probation will put for no months. And then let's put, I don't know, Ms. Robinson, do you know, should we put it out? Should we delay the order with the other, I don't know anything about the other civil file that's out there, but I could delay costs or 90 days or.
Yeah, I think we can delay it for 90 days and then
Yeah,
if she's like still in, I doubt that she'll still be in at that time, but if she is, then we can follow up with it.
Once you're able to, you should make arrangements. This all go to the same.
Go to this court.
Yeah, that's.
Because I've had a payment plan for 25.
All right, and that, I think they'll just lump it all together, but. So let's make, let's do 90 days, October 4th. October 4th. All right, so you should be all set on this file, Ms. Culberson. You've got 90 days. If you're still incarcerated with that 90-day period, which I don't know if you will be or not, but you should contact and let them know where you are. Okay, just so that'll keep you out of the show cost cycle.
All right, thank you.
All right, anything else for the record in 2503647, Mr. Smith?
From the people, Your Honor.
Ms. Robinson?
No, Your Honor, thank
All
you.
right, you should be all set. We'll see you. Yeah, let's do a pretty one since I've marked all over that. All right, then you wanted to. Who's covering for Ms. Donnelly? Is that Ms.?
I am, Your Honor.
All right. Let's go on Mr. Rogers.
Good morning, Your Honor.
Good morning. All right, so we're on the record in 2503484. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Assistant Public Defender Jessica Straub on behalf of Mr. Rogers, who is standing to my right.
And it's Straub, right?
It is.
Okay. I know you were. I know you've been in Judge Simmons' courtroom. All right, and sir, you are Robert Rogers. Is that correct?
Yes.
All right, thank you. This is time set for a review hearing. I think we have a competency report. We set this out for review, and it's my understanding that we're still waiting for the defendant to be found competent.
That's
Is that
also
correct?
my understanding, Your Honor.
All right, Mr. Smith, is that your understanding?
Yes, that's my understanding, Your Honor.
All right, so what I'm going to do now.
Can I enter a motion?
No, you probably shouldn't, okay?
Well, I do have the competency paperwork and Judge Tremblay's got that.
All right.
You did contact her, right?
That's between you and
Okay.
Judge Tremblay. We're just
Well, they pulled the fire alarm in 54A district in front of Judge Alderson. That's a contempt of court.
I don't know anything about that.
I know it. You might want to get with Judge Alderson on my
Right.
case.
She's retired.
She's going to a court of appeals, I heard.
No, she's retired.
Is she? Okay?
Yeah, I took her spot.
Did you?
So, yeah.
Yeah, that's cool. She was a brilliant woman.
Yeah, so let's, we probably need to set this, but we also need a timeline.
Can I ask one thing? Why can't I contact the prosecutor's office? With evidence?
Because you have a lawyer.
Well,
Yeah,
before
so
the lawyer stepped in, I got a little bit of evidence of them pulling the fire alarm, stealing my forensics.
Yeah, you probably should keep
got
hold
that.
of that, but,
Okay.
but Miss Donnelly, you probably should contact Miss Donnelly, because they're not allowed to speak to any, they're not allowed
Why
to
am I
speak.
remaining silent?
Because.
They're not allowed to speak to you because
Who's not?
the prosecutor's
Okay.
office can't talk to you.
Well, when I turned in a federal crime on the HIPAA violations, that came back and O'Donnell's in 55th District Court. She got ordered to go there to do
Right.
that. Well, I
Right.
got a police report with Mike Jankowski, and there's another HIPAA violation, and you might want to get this one and look at this because it's a threat,
All right,
right? And then there's
You
threat.
need to share all that with Miss Donnelly.
Okay, I will.
Okay,
And you will let you see that. So that we got,
All right.
there's federal felonies on that.
all right. So Mr. Smith, what is the timeline on, because I think, what is the timeline on Mr., because I think he was arraigned February 19th, 2026.
Let's see.
And we're waiting to find competency. We have the report.
2-3 okay, here's the deal. January 1st, 2015, I went to competency, got out February 3rd on my birthday for Judge Flores. And it went to Judge Alderson's courtroom and they pulled the fire alarm. And Stephen Bilks was my attorney.
Right.
And he knows about the competency paperwork. That's obstructing justice when they pulled the fire alarm and stole that. Robert Merritt was there. And Dolores Zarka worked in the courtroom and she come out and told me they put popcorn in the microwave to steal my forensics. And I got her as evidence.
All
and we
right.
will contact her as a
All
witness.
right. So what's our time frame for Mr. Rogers?
Yeah, what's the time frame of that when they pulled the fire alarm? That's
No,
obstructing justice. So
For this file, because we're gonna set it some time out. I think he's in the 15-month range.
you know, I got Stuart Dunnings fired. I did. I got Stuart Dunnings and pandering charge they dismissed on him.
So let's
Looking up that time. right?
yeah, because I think the prosecutor's office is gonna have to make a decision.
Yeah, it's either 15 months, Your Honor, or my understanding is it could be also a third of the maximum, right?
Third of the maximum,
Yeah.
and we're looking at a 5-year.
5-year.
That you're charged with an aggravated stalking, which is a 5-year.
What's the, can the state bring that up or is there gotta be a victim? There's supposed to be a victim in a state case, right?
I have nothing.
I'm just saying, I watched that on.
The people
There's
have
gotta be a
to.
victim for a state case, right? The state can't take over a case without it being a victim
That's
being
not true.
stalled.
That's
No,
not-
they can.
Okay,
Can.
state can do that.
Yeah,
Can we
state
sue them
can do
for
that. They
HIPAA
still have to prove
violations?
their case. They have to have. They have to have.
Yeah, they gotta have
witnesses.
proof, right? You show me the proof and then I'll go from there.
Hold on.
Right. I want it to be honest and truthful.
It was. I think he was arraigned in February of 2026. I think February 19th, 2026. So
So I don't think we're.
you aren't close, but I want to make sure that I write down the date. So
I got the
that-
forensics too.
I do think it's February 19th.
February 19th. All right. So let's adjourn to find competent.
Oh, well, they said this was in the courthouse and the same time I got a PPO with Judge Alderson and Judge
You gotta
Tremblay.
let the judge do their.
Right.
All
Can I ask
right.
for an investigation, Your Honor?
You'll have to talk to somebody but you probably should talk to your lawyer.
Well, I asked for an investigation. Her investigator for Sarah Donnelly has a live video on Facebook with me. And I told him all the evidence that I
All
had.
right.
So there is a live video on Facebook with the investigator for Sarah Donnelly.
All right.
And he already knows that because I proved it to him. And I
All
showed him.
right. So we'll adjourn this, I would think 60 days out. Yeah.
Okay.
So we'll get a date 60 days out for competency review.
Now, when we know there's federal felonies in the courtroom, who do we report that to?
Probably the federal prosecutor.
Because Mr. Grill over in Meridian Township told me to get with the FBI because they wouldn't take a police report on that.
That'd be all federal.
Okay.
So this is all the state
Okay,
level.
so I should step into this
So
federal.
60 days, Your Honor.
So 60 days would be,
We're gonna have to wrap it.
okay, September 14th.
You might want to get all the paperwork out of the city attorney's office.
At what time?
Okay.
At 1:30. So we'll adjourn to September 14th at 1:30, and at that date, on September 14th, we should have a date, just sometime, because we'll probably set it a month before, so that we have a full understanding of what that'll give the prosecutor some time to
I bring my
decide.
competency paperwork to you right now when we see it.
No,
Can I enter it?
We're just waiting.
Motion?
We're
Can
just
I enter a
waiting.
motion? I got a copy.
Not on this file. You
Okay.
can't.
I
Okay.
do have competency from Judge Alderson
All right.
and Judge Felice.
And so that would probably be about, I don't know, Alderson's 5 years old and Felice is probably
10.
8 years, 8 to 10.
When they pulled the fire alarm in front of Judge Alderson, you should
Yeah,
know about that
that's-
court case.
That's a problem.
That was obstructing justice.
We need a current
Right,
competency.
that's fine. We'll do a current
Right,
one.
yeah.
But here's the one thing. I'll go to forensics. Minimum's 30 days, right? I ask for one motion on that.
I think you've
Will
already
you do a
been.
medical evaluation of my neck?
I think you've already been to forensics. I
Right,
think we're
I
just
will go to
waiting
forensics for my neck evaluation. I got it.
review.
I got it right now.
All right, so September 14th at 1:30 for competency
I'll send it to you
review.
by email. Thank you.
And Mr. Rogers, you should be all set. We'll see you back here September 14th at 1:30, and you should have the notice.
Okay.
Okay?
Thank you very much.
Your Honor, if I may, Mr. Rogers also brought to my attention that he would like to bring a motion regarding his tether before the court. It appears that he does outside work involving trees and on ladders, and it does present a bit of a safety issue for him. So if the court would be amenable to removing it.
Sarah Donnelly said I'm not stalking this
Mr.
guy. She
Smith.
already knows.
I oppose that, Your Honor.
Yeah,
Okay.
yeah, I think
This guy
judging from the.
supposedly moved when he got HIPAA violations. I'd like to, I
He
don't
may-
care where he
may
did.
have, but I think the GPS is probably a good idea.
Thank you.
What do we do with HIPAA violations?
Talk to your attorney.
Yeah,
Okay.
talk to Miss Donnelly and Ms. Straub is just covering for her today, okay?
Okay, that's why I was like,
Yeah.
so this should have been dismissed as case today and rescinded when Sarah was back in court.
It probably won't be.
No, I mean,
you probably won't be
it's like
looked
that.
at it till September 14th,
Okay,
okay? All right,
thank you
should
very
be all
much. You have a
set.
nice day.
Yeah,
Thank you, Your Honor.
Thank you, Ms. Straub. Thanks for covering today.
It's not.
Then I said, yeah.
I was like,
I remember.
You remember? Well, I don't know. All right, and then we'll go on Micah Shabazz. That's.
yeah, you probably won't wait till the
All right, so we're on the record in docket 25-00666. That's people of the state of Michigan versus Micah Shabazz. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Good afternoon, Your Honor. Linda Rawls, Assistant Public Defender, appearing on behalf of Micah Shabazz, who's present in court.
And sir, you are Micah Shabazz, is that correct?
Sir.
Okay, thank you. This is the time set for a sentencing in the matter. And Mr. Smith, do you know of any further restitution in this matter?
No further restitution has been brought to the attention of the
All
prosecutor's
right.
office.
I don't have any further restitution from the pre-sentence report or from the recommendation. Ms. Rawls, have you had the opportunity to go through the pre-sentence report with your clients?
Yes, Your Honor.
Any additions, deletions, or corrections?
Other than at the time of the PSI, the credit was 151 days.
All right.
It's an additional 12 days.
So it'd be 163?
Let me see, it's
It was
additional
151.
six, yes,
So-
151.
Plus 12.
Plus 12 is 163?
Well, 12 would make July, so it would be 16.
Okay, so 160, 167.
That is correct, Your Honor.
All right. Any objection to credit for 167
No
days
objection,
in
Your
New
Honor.
County Jail? Okay. Right, allocution, Ms. Rawls.
We respectfully ask that the court follow the pre-sentencing report.
All right. see which one was. Due date. Yeah, this is July 6th. This is today's. All right, any comment, Mr. Smith?
Yeah, Your Honor, I ask that you follow this sentencing recommendation for probation.
All right, Mr. Shabazz, is there anything you'd like to say to the court before the court passes the sentence?
I'd just like to say that, if I may, just trying to be trying to get this past me. I don't have any more court, nothing to do with trouble after this, and just trying to make it back out to the community, be a productive member of society.
All right. You don't have any other open files?
Nope.
Okay. All right, so this is for a guilty plea. I think. On April 25th, 2025, and then we've had some remands and then failed to appears. But I'm going to adopt the recommendation of the pre-sentence report. Mr. Shabazz, you're not a kid. I'm not going to treat you like a kid. This is, I mean, there's only so many places you can go now. You know, you've been through the district court sentencing, and then and probation. You're not a candidate for probation for district court. That's why we're sentencing this, and you kind of understand that. You've kind of seen the yeah. So there's only so many places now that for you. You seem to have turned things around, but you know, that's your call. That's your call, sir. All right. So this is for a guilty plea of last year. I'm gonna set fines and costs. Fines of $100, cost of $100, crime victims' rights fee of $75. The adoptions recommended that you spend 167 days in jail with credit for 167 days previously served. So it's spent 167 days jail, beginning credits given for 167 days previously served. There'll be no probation in this matter. We'll set fines and costs $100 fine, $100 cost, crime victims' rights fee of $75. State minimum cost fee of $50 for $325. That's the total. There'll be no amount for probation. And so there'll be no additional jail. Okay, that ends any our experience with Mr. Shabazz, with the understanding that, you know, hopefully there won't be a next time. Okay, because next time there's got to be some decisions made on what's going to happen here. All right. Anything for the record, Mr. Smith?
Nothing from the people, Your Honor.
Ms. Rawls?
No, Your Honor.
All right. Mr. Shabazz, good luck to you, okay?
Thank you, Judge.
Thank you. Yeah, that one's got my writing all over it. Does he have an open phone, please? Because we could refer that.
Oh, no, you can take that.
All right, let's put that due in 90 days. We'll put that due in 90 days.
You gotta go with it.
I need to write that on.
Yeah, due in days, fines and costs. I'll write it down on this, and then you can make it all pretty. And what date were we using 90 days out?
So total due, and this is on here.
Okay.
Let me read it.
Yeah, that's one to make pretty. 'Cause otherwise.
I received the information back on.
Oh, okay.
He's in custody right now, so.
All right.
Yeah.
That's the pretty one.
Yeah.
Um,
325. Total due October 4th, 2026. So. It always goes in the one I don't think it's supposed to go, so that. Until it's moved. Until they move it.
The last judge, the last thing we have on is,
Joshua Emmerich,
yes,
did you want to get
that's not
230? All right.
So.
Let me see if we got any civil that is ready to go.
My buddy Paul is working for Judge.
So Ms. Costin, you're here for your 230 with Bloomfield Financial. You'll have to unmute. Amber Costin. I don't see anybody else here. I would assume she's here for her 230. Yeah. And I don't see any lawyers in there. Let me jump on.
take that off.
All right, so Mr. Goodman, you're here for Mr. Posett, or is that's 0713881?
Yeah, that's the file.
All right.
Mr. Posat was my old law partner many, many years ago.
All right, all right. All right, and then Ms. Costin, that's your motion and you're gonna have to unmute, ma'am. Ms. Costin, you're gonna have to unmute. So Mr. Goodman, we'll wait for Ms. Costin to unmute and then we'll call that case. I think that's her motion.
Okay, can you hear me now?
Yeah. Are you
Okay.
ready to go on your motion, ma'am? All right.
Yes, sir. Yes, Your Honor.
All right, so we're on the record in 0701381. That's Bloomfield Financial versus Amber Costin. Appearances for the record, Mr. Goodman.
Good afternoon, Your Honor. Robert Goodman. My P number is 55670, appearing on behalf of the plaintiff.
And ma'am, you are Amber Costin, is that correct?
Yes, Your Honor.
All right, thank you. This is the time set for a motion today. And I have the motion in front of me. So I'll read it into the record and then you can, and Mr. Goodman, did the parties want to speak before the actual motion? I don't know the name of the motion. It's so I don't know, but I can read it into the record. Did you want to speak with Ms. Costin?
If she'd like to talk, I'm happy to speak with her. Your Honor, I will indicate to the court that we received this motion on Friday. And so we whipped up a quick answer and filed a response. I hope it's made it to your court file.
All right. I don't know if the answer has made it to the court file. And I see that the motion was filed on July 6th. I'm sorry. That's today. The motion was filed on June 23rd. Is that correct, Ms. Costin?
Yes, Your Honor.
All right. Did you want the opportunity to speak to Mr. Goodman? I can place you in a breakout room, or did you want to go forward with your motion?
I can go forward with it. I just have to ask him a couple questions.
Well, then I should put you in a breakout room before you go forward with your motion.
Okay.
Happy to
All
talk.
right. So let's do that. Ms. Costin, I'm going to place you in room 2, and then we'll come back and put it on the record. And then Mr. Goodman, I'll also place you in room 2.
Thank you.
All right. All right, and Quintel Foster, you're here for Credit Acceptance Corp versus yourself. You'll have to unmute.
Yes, yes,
All right.
Your Honor.
All right. So it's scheduled for 2:30. We'll give Mr. Werber 15 minutes grace time to get here, okay?
Okay.
All right. So you're in the right place, stand by.
Okay.
Not at all. None of my apartments.
You remember that?
Mm-hmm. This man's, he's lying. And big boy, I would have got served at this house.
It's probably not important that you got
Mr.
served.
Goodman, you can unmute. All right. Mr. Goodman, you had the opportunity to speak with Ms. Costin in a breakout room?
I did.
And did anything, what if anything came from that, from meeting with Ms. Costin? Are we going forward with the motion today?
Judge, we're going to go forward with, I believe she wants to go forward with the motion. I did
All right.
answer her questions and refreshed her recollection regarding the account. And I'm happy, we don't have it resolved, so I think she probably would like to move forward with her motion.
All right, I have, Ms. Costin, I have that you never, a part of your motion, and you said you want judge to satisfy, and then you've read one, never had credit cards per credit copy of credit report bureau, plus the address is my ex-husband's, never lived at the address above. Do you want to supplement that motion in any way, ma'am?
No, Your Honor. But I know what he told me about the household finance.
Okay, so you don't want to supplement that, and you had the opportunity to speak with Mr. Goodman, is that correct? All right, in response, Mr. Goodman.
Thank you, Judge. Were you able to find our written response that we filed with the court on Friday?
I was not, let's see. I have yes, I have an answer to the defendant's motion to satisfy judgment.
Perfect. That's what we filed.
Is that what you filed?
Yes.
All right.
And so Judge, if I may, I would just quickly highlight a few things on that response.
All right.
If the court would like to hear it. I don't know.
You may proceed.
All right. We would just simply indicate, Judge, that this was an action that was filed back in 2007. The defendant was personally served with the summons and complaint at that time, failed to file an answer, and on May 3rd, a default judgment was entered. There's been significant collection efforts over the years. We did highlight for the court a wage garnishment that was filed back in January of 2016 at a Big Boy restaurant, in which we received a disclosure from her employer that she in fact worked there, paid bi-weekly, and that garnishments would commence. And then approximately 2 weeks later, we received a final statement on garnishment. There was no money attached, and the defendant's employment had terminated, presumably because she quit because of the garnishment. We've indicated that the original creditor in this account.
All right, Ms. Costin, we can hear you coming through, and it's Mr. Goodman's turn to talk. All right.
I'm sorry.
All right.
So
go ahead, Mr. Goodman.
Further in our response, she indicates she's never had a credit card, that this doesn't appear in her credit report. Not that that's so relevant, but we did attach, Judge. We happen to have kept copies of a credit report we pulled on June 7th of 2006, and then another credit report that we had pulled on September 27th, 2010, both attached as exhibits to our response. In there, you can see that household finance was listed among other credit cards and other collection accounts that she had. And if you look at the attachment to our complaint, which specifically identifies the original creditor as household finance and a particular account number, that being 8500147137, you can also see that those accounts are reflected on those two credit reports that we attached as exhibits. And so here we are, so many years later, when there is finally a garnishment in place and we are receiving funds, she's asking the court to now satisfy the judgment and claiming she knew nothing about it. We had asked the court that there's no support for that, and we would ask the court to deny the motion.
All right, thank you, Mr. Goodman. Ms. Costin, response.
Yes, Your Honor. Like I was saying, the credit cards, I've never had any. My ex-husband did. I don't know if that pertains to this case, probably not. But I do know that he did use household finance to get furniture and other things when we were married.
All right.
So, but I
And
have nothing. Then as for, I'm sorry. Go.
you can proceed, ma'am.
Okay. And as for him saying that I quit, the reason I left that establishment is because they were giving me 2 days a week and I couldn't pay to even do anything with that. Plus I was getting whatever tips or whatever, and that just didn't amount to anything. But I have not been, with him saying I've been served, I've not gotten served at all.
Great. And Mr. Goodman, this is the last address, the 1516 Gallery Place. That's the correct address. I just want to make sure you have an updated address.
Yes, Judge, that was on the motion that we received on Friday, so that's what we used with our response.
All right, yeah, and that, so Ms. Costin, you're confirming that that's the 1516 Gallery Place Drive, number 4, Jackson, Michigan address?
Yeah, yes.
Okay. All right, I'm gonna deny the motion at this point in time, based on the arguments that have been indicated. And Mr. Goodman, you'll prepare an order to that effect, considering the denial of the motion. The motion title is just want the judge to satisfy. I don't think that's, but if you do, but I will look for the order indicating that the motion was denied, Mr. Goodman, and then you can do the order, and I'll follow. That'll be signed by myself. If not this afternoon, tomorrow, during probably the afternoon of when you would submit it.
Thank you, Judge. I did prepare a proposed order denying the motion. I attached it to my response, the very last page behind the proof of service. If the court has that one, great. If not, I'm happy to e-file it again.
Well, just in case, refile it, and then if I can't find it, it'll be presented to me. I just don't know where it is. Okay. It might still be in civil. I don't see it, and so I'm fearful that I don't have it yet.
No problem. I'll be happy to e-file it right now.
All right. So I will deny the motion, and Miss Costin, thank you for your appearance today. You should be all set.
Thank you for the court's time. Take care.
Your question.
I'm sorry, Ms. Costin, you're breaking up.
Oh, I'm sorry. I just want to know what is denied. You denying me, right?
Yeah, I've denied your motion, ma'am. And the order and a follow-up order is going to be done by the opposing counsel.
All right, Your Honor.
All right, thank you. All right. Right, and Mr. Werber, you're here on the motion for summary disposition, and then we've set this for pretrial on the same date. Is that correct?
That is correct, Your Honor. I know Mr. Foster contacted my office earlier today, I think to discuss a resolution. I'd be happy to go in a breakout room.
All right. Mr. Foster, would you be amenable to meeting with Mr. Werber in a breakout room? You can unmute.
Yes, I will.
All right, let's place you in a breakout room and then we can always call the case. So Mr. Werber, I'm gonna have you placed in. Let's place you in room 2, and Mr. Foster, I'll also place you in room 2.
Oh.
Now I can do my notes. I didn't know what to call her motions because her title was, I guess she's attacking the 2007 because it's really in collections now.
Yep. From the phone.
We get that all the time with
TVs, they want to get it in because
they were married at the time and then, but she does have to find the ex, and she probably, who knows what happened, you know.
someone's still trying to break this.
And Mr. Werber, I can bring back Mr. Foster.
Yes, absolutely. We're ready and we did resolve it, Judge. We're gonna place our resolution on the record.
All right, let me bring him back and we'll put it on the record. All right, so we're back on the record in 26011695, and Mr. Werber's indicated he had the opportunity to speak with Mr. Foster in a breakout room. Mr. Werber, what, if anything, came from that meeting?
Yes, thank you for giving us the opportunity to speak, Your Honor. The parties have agreed to resolve that. If you're ready, I would like to place the resolution on the record.
You may proceed.
Great. So the parties are going to enter into a conditional dismissal. The defendant is going to pay $1,605 due on or before October 6, 2026 to settle this in full. As long as he makes that payment timely, the case will remain dismissed. If he fails to pay as agreed, I'm going to write him a default letter. I did confirm his address, giving him 7 days to cure. If he still fails to pay, then the plaintiff can set aside the dismissal and enter a judgment for the full balance of $7,835.41, plus any court costs. I provided the defendant with instructions on how to make his payment directly to my office, and he is willing to give me consent on the record to sign his name to that conditional dismissal and get it filed with the court.
All right, thank you. Mr. Foster, did everything that Mr. Werber indicated was part of your agreement?
Yes.
And do you give Mr. Werber permission to sign the document to advance to the court?
Yes, I do.
All right. Then I'll await the order to follow. The terms have been placed on the record for the conditional dismissal. Anything else for the record in 2601-695, Mr. Werber?
No, thank you, Your Honor.
Mr. Foster, do you have any questions of me?
No, I don't, Your Honor.
All right. I'll await to sign the order. Thank you both for your appearance today.
All right.
Thanks, Your Honor.
Thank you.